Hi, my name's Lydia, and this short video explains what the council can and can't do with regards to noise complaints. It gives you information on how you can tackle the issue yourself, as well as outlining how we investigate noise complaints and what action we may take. Noise is normally thought of as unwanted sound. It can be unwanted due to the time of day it happens, it's too loud, or because it happens repeatedly or unexpectedly. For noise to be considered a statutory nuisance, which the council must investigate, it has to materially and significantly interfere with the average person's use or enjoyment of their property or be prejudicial to their health. This threshold is much higher than noise which is simply annoying, inconvenient or irritating. There are many different factors the council will consider to determine if a noise amounts to a statutory nuisance. It is not a quick fix and, as will be seen later, can take time. You should also be aware that the council cannot investigate certain types of noise. The courts have determined that sounds of everyday living cannot be actioned, and this includes children playing, conversations, doors closing, toilets flushing, babies crying, dropping objects, poor sound insulation, footfalls on laminate flooring, noise from the highway such as car doors closing, manhole covers clanging and traffic noise. The council can investigate noise such as amplified music and noise from televisions, DIY activities, barking dogs, noise from business premises including factories, pubs and clubs, noise from machinery in the street to name a few. Further, the council will deal with all noise complaints in an impartial and unbiased manner and based on evidence. We do not take sides and do not take action due to simply falling out with your neighbor. Our experience shows that the person causing the noise is often unaware that it is causing an issue, or is unaware of the impact it is having on others. With this in mind, the council always recommends that you speak directly to your neighbor first. An informal approach between neighbors can resolve the issue far quicker than the council can, and it can prevent it escalating into a bigger issue. Before speaking to your neighbor, think about what you wish to say. Be clear and precise about your view of the problem. Be calm and don't get involved in trading insults. Bang on walls or hammer on their door in the middle of the night, as this will only inflame the situation. It is best not to talk to them when you are angry or upset. Leave it till later, but don't let it fester. Take the view that together you can find a resolution. And be reasonable. You should not expect silence and be aware of the other person's opinion or different lifestyles. Always keep a safe distance and be prepared to walk away if the conversation isn't going well. The council recognizes that this might not be an appropriate course of action in all cases, and for this reason we have published 2 different letters or notes you can pop through your neighbor's door. These can be found on our website, or your investigating officer may have already sent you a copy. If an informal approach didn't work, the council can investigate. The council will not tell the other person who has complained, but they may be able to guess who it is. The council will not investigate anonymous complaints. Further, you should be aware that if you sell your house, you must inform the purchaser of any noise issues, particularly if they have resulted in an investigation by an official body such as the council. If you rent from a social landlord or housing association, you must make your complaint to them first and allow them to investigate. The first stage to any investigation is to collect evidence of the noise and how it is affecting you. You will be required to complete diary record sheets for a minimum period of 2 weeks. If you have a smartphone, you may also be offered the Noise app, which also records the noise and sends this direct to the council. You must log the times of day, duration of the noise, and note how the noise is affecting you. The person who is allegedly making the noise will also be informed that the council has received a complaint and that they are being monitored, therefore you must provide an address of where the noise is coming from. Diary record sheets are an important step in any investigation and will provide the basis as to whether the investigating officer will continue with your complaint. The diary sheets should be a complete and accurate record, as they will be used as evidence in any enforcement action or used in court should the issue result in prosecution. You may return the diary record sheets to your investigating officer by post or preferably by email. Once you have returned 2 weeks' worth of completed noise diary sheets, the investigating officer will review the information along with any recordings you may have made using the Noise app. They will look at things like the time of day the noise was occurring, how long it was going on for, how often it occurred, and how it is affecting you. The officer will be unable to take into account any sensitivities such as pre-existing health conditions or, for example, if you work night shifts and cannot sleep during the day. The key element to any noise investigation and determining a statutory nuisance is whether the noise is unreasonable to the average person. For example, a one-off loud party a few times a year is unlikely to amount to a statutory nuisance, but if the party is every weekend, this is likely to be unreasonable. Noise from DIY all day on a Saturday is unlikely to amount to a statutory nuisance, but if it occurs every evening until 11 p.m., then that may be seen to be unreasonable. Each case will be dealt with individually and based on the information you have provided in your diary sheets. If you fail to send these back to us or do not complete them, the council will be unable to take your case any further. If the investigating officer believes, from your diary sheets, that a statutory nuisance is occurring, then they will arrange to install noise monitoring equipment in your property. This is usually for 1 week. After a week, the equipment will be collected and the recordings will then be listened to by 2 officers to ensure consistency and transparency. Your investigating officer will then decide what action to take. If it is decided that the noise does not amount to a statutory nuisance, then no further action will be taken and the officer will close the case. If it is decided that a statutory nuisance does exist, then the person making the noise will be served with an abatement notice. This is a legal notice that describes the nuisance and directs that it is to be abated, reduced or diminished. The person receiving an abatement notice can appeal this in the magistrate's court. This is another reason why the diary sheet evidence is so crucial. If, on the rare occasion, the noise continues, you will be required to continue providing diary sheet evidence, and we may install noise monitoring equipment again to show that there is a breach of the abatement notice. Breaching an abatement notice is a criminal offence. The council have a number of options, and this may include applying for a warrant to enter the property and remove the noise-making equipment, or they may prepare a file for the council's legal team to potentially prosecute the person who is making the noise. This will also depend on the evidence provided and whether it is in the public interest. You may be required to provide a witness statement or appear in court yourself. Hopefully this video has given you a greater understanding of what the council can do with regards noise complaints and what you will need to do to show that a statutory nuisance is occurring. To summarize, making a noise complaint to the council is a serious undertaking and can take time. It is not a quick fix, and requires you to provide evidence over a period of time to establish that a nuisance exists. Firstly, a statutory nuisance, which the council must investigate, is not for noise that is simply annoying or irritating, but which is having a significant detrimental impact or is prejudicial to your health. Prejudicial to health must be confirmed in writing by your GP, and we are unable to take into account pre-existing health conditions or any sensitivity to the noise such as shift work. Secondly, you should always make informal contact with the person making the noise, as this can resolve the issue much quicker than the council can. If you are a housing association tenant, you should contact your housing provider rather than the council to investigate. Remember, the council will not investigate anonymous complaints, and you must provide an address or location of where the noise is coming from. Finally, you can always take your own legal action against the person making the noise under Section 82 of the Environmental Protection Act.